Court is in session today, Khalif, and we are going to be talking about this first case here. New York man suing ICE leaders of the Department of Homeland Security for sending federal officers to his door, as you see right there in that picture, warning him about an email that he sent to a former head of the agency.
Yeah, this was when I first saw it, I'm like, well,
What?
let me make sure I'm wrapping my hands around this, right? Let me see what the threat is. Let me figure out what the man said and what prompted officers to come to his door. And so the threat, it's an email, right, that he sends over, and they first say that this is a warning notice. You may be in violation of federal law, referencing federal law prohibition against threats against federal officers. The notice states that ICE officials of professional responsibility had identified an email that may violate federal law and request that you promptly remove. It's the part that I believe his attorney has issue with. Promptly remove or discontinue the aforementioned behavior. This man.
Let's
Go
talk
ahead.
about what he said here, in that, because he's claiming free speech.
Yep.
David Striever is his name, and he's saying that they violated his First Amendment to free speech. But he, after emailed the ICE acting director Todd Lyons, call him a quote monstrous human being.
Yep.
And saying he will never know peace and will torment himself until his last day on earth.
Yeah, there are a couple things that jump off the page, and I'm not laughing at the comments. It's just, first of all, the creative writing of trying to say something like that. He says his rationale was that he just witnessed the shooting, and I'm writing an email because I was deeply upset about the shooting in Minnesota, and I felt compelled to do something. Write an email to the head of ICE seemed like the least I could do to express my frustration, my sense of outrage. ICE responds and says, look, we take credible threats completely serious, and our employees and our officers should not be subject to these type of threats. And we this is a matter that we take serious, right? I think there are a couple things you first want to look at. This is not a question of, can ICE investigate these type of threats? I think the answer is 100% yes. And I think you'd have to be blind to not see that there is at least the potential of a threat. So yes, have the investigation, but then the question is this an investigation, or is this retaliation against protected First Amendment speech? Are you attempting to chill my speech? And that's why I read the comment about promptly remove, right? Promptly take this down, because now that I'm attacking the content of your speech, something that you said was not content neutral. I don't like what you said, and I want you to take those specific words down, which would, again, be coming at content specific, not content neutral, which the government's going to have to prove a compelling public interest, and it's narrowly tailored as to why they can chill your speech in this type of forum. So that's the argument that you would go down when you're looking at, do they have a right to stop you from saying these types of First Amendment protected comments? And then second, have you now retaliated against me for doing something that's protected? I think if this one goes to trial, which this organization that represents him is saying that they would like that to happen, a couple of things will have to occur. First, you're going to look at the timing of the threat. Well, did you sit on your hands when you were threatened? Because typically a communicating threat is this imminent fear of bodily harm, that a person makes a comment towards me that I feel like they are going to act on that
We've
threat
seen this type
now.
of thing with school threats all the time.
Correct.
Making a threat. You need to act upon that, correct?
Right. So
Protection of and public safety.
did they act on it? In their complaint, plaintiffs say no, they didn't act on it. They sat on their hands for 5 months and waited. And so their argument is that if you really believe that you were threatened, why did you wait so long? On the other hand, Homeland Security and ICE will come back and say, well, hey, we were investigating, trying to figure out and find out, well, where did this email come from? Who was the person that owned it? And then we actually now go from this internet space to the real world, and we have officers showing up to your house. That's not going to happen in one day. It's going to take time for the investigation to run its course for us to get there. Once we figure that out, now we're here. I think that's the argument that they make, but I think there are legs to this case for sure. I think there is an opportunity for this to at least make its way to a courtroom where you have depositions, interrogatories, get through the discovery process, try to figure out, well, what was said, how was it said? We know the language. But were there any other things? Was there intent to commit harm? What would a reasonable person believe when they read and saw that email? Do you think saying, you won't find peace to the end of your days, is that meaning that I will be the cause of you not finding peace? Would I be the cause of you not finding it will I be the cause of the end of your days? Like there would have to be a number of assumptions to get to the point of his statements being a threat, if it ever went to trial on the criminal part. And then the other portion is, this is what they'd argue. So they sat on their hands for 5 months. No one has ever been charged with a crime. So if you're believing that it was a communicating a threat against a government official, there should have been a charge for, some adverse effect of action, specifically saying, hey, now you've been charged with a criminal charge and you have it. So I think that's going to be the strong portions for plaintiff's case.
Can it set new limits on here on how far federal officials can go when acting on tips or online communication?
I don't think so. I think, I mean, if I'm representing ICE in this scenario, and I'm not encouraging them to go out and arrest people randomly, right? But if you believe there's a genuine threat, then the proper thing to do is charge. Don't warn. Don't say, hey, we believe this is a potential threat. No. If you believe someone is threatening an individual that's connected to your office, or it's an agent, if it's an officer, if it's someone that's administrator, if they've met the legal standard, and what plaintiff's attorney says is that they don't. And that's why they didn't charge. But if you believe that standard is there, that you meet the elements, like you have the intent to commit this crime, then charge. So then now you're not in a situation where you're waiting time and you're not having an opportunity for them to say, well, waited forever and you didn't charge me. The other thing is they brought up in their complaint is other opportunities, I should say, other instances of these types of things happening. They brought up a poll worker and a comment that she had made, and they're saying she made this comment, and because she made this comment, they were asking her to take it down because she potentially doxed an ICE officer. This is in their complaint. They're saying, so this is a pattern. This is a behavior of them going out and trying to chill individual speech, to retaliate against them for First Amendment protected speech, things that they're saying you shouldn't be able to do. The woman, to her defense, said, I didn't dox this guy. His name was already in the newspaper. I just repeated what was in the newspaper. They're alleging that she had repeated his name and given his address. The giving the address with the intent to commit harm would be different. Her attorney says, listen, even if thy client gave his name and his address, still wouldn't be a federal offense because you have to show that intent to commit some type of harm. Saying, hey, here's his name, here's his address, let's go to his house. That's that intent to commit some harm. Putting a name and an address, while it's probably not the best idea, I don't think it meets the standard for something that would be illegal under the federal charges that they were attempting to say. So those are examples that this individual's complaint has listed in there as it's a way to show a pattern of attempting to chill the public speak.
Queen City News Plus. Just search Queen City News on your smart TV's app store.